that it's still very, it's necessary, I think, to prevent us from getting into an area where decision makers are just using their subjective hunch and saying, this is the end result that I want to get at. But I don't know if that's really getting at your question about separating out the two.
Do you have anything you want to add to that, Mark? Or?
Oh, no, we are.
And then Carmel, my second question, one of the things I really appreciated, sorry, did you?
No, I think we're out.
I think we're out.
Oh, we're at the end of time. Okay. We're good? Oh, okay. Carmel, one of the things I appreciated was your emphasis on reasonable accommodation within the context of minimal impairment. And just one thing that maybe to consider a little bit further is the role that the proportionate effects stage plays in the Section 1 administrative law analysis. And it strikes me that what Doré does is essentially reverse the consideration such that the focus of proportionate effects is placed on administrative objectives rather than, as Professor Cameron was urging earlier, on the deleterious consequences for the charter entitlement in question. So I just would like to hear your thoughts on whether a revised framework should rebalance this consideration so that proportionality trends more toward affirming charter entitlements.
Yeah, I mean, I would agree that I think Doré kind of flips it. I mean, I think that's kind of what the dissent in TWU is getting at when they talk about how that under Doré, the charter rights are protected only so far as they are consistent with objectives of the enabling statute. And so I do think that, this idea that when push comes to shove, statutory objectives, including presumably unconstitutional ones, trump the right. And I think that's a very valid critique. And I mean, I think what I'm hoping is that if you add further steps in the analysis earlier, that by the time you get to the proportionality analysis, you've hopefully eliminated some of that because you've already really scrutinized the objective that you're weighing at the end of the day. But I think, yeah, it's a very valid consideration that the way it currently is I don't think that it's not preserving the charter rights to the extent that I think Section 1 demands of it.
Brian, do I have time to still ask questions of Mark? Okay, I'm getting the green light here. So Mark, if you don't have any response to that, I'll just kind of go into my questions for you.
Can I say?
Yeah, please.
Yeah, I think it's a really great point about the front loading of some of the work in the Oakes test and administrative law specifically. And I'm thinking here of the objective part, scoping the objective properly. I think in administrative law, just like when an administrator interprets his or her own statute, the administrator has to scope the purpose of the statute appropriately. And same in this context, the administrator is going to have to scope the importance or show why the objective flows from the statute in a way that's justified by the statute. In the Federal Court of Appeal recently in Alexion, Justice Stratus strikes down a decision because of the Patented Medicine Prices Review Board because they abstract the purpose of their statute to such a high degree that it ends up subsuming what the statute actually says. And so that's an erroneous interpretation. And we should be scrutinizing objectives, I think, in administrative law, much the same way and under the Oakes test. Now you have another question, I guess.
No, but
no, that's it. That's all I'll say on that.
Yeah. Okay, well then I'll get into some specific questions regarding your draft. And my first question is whether under the Oakes test, whether it's suited to the judicial review of administrative decisions under the two-part framework that you're proposing in this draft. Bearing in mind that part of the rationale that was provided in Doré for why a new framework was needed was because Oakes presumes a sort of legislative analysis, both textually and contextually. So do you think that Oakes, as it stands currently, needs to be further amended or perhaps adapted is the better word to fit the administrative context?
Yeah, I think the first thing to say is that this isn't impossible. And I think what, again, Justices Brown and Cote and TWU point out that there are many cases pre-Doré where Oakes was applied. Maybe it was modified a bit, but it was much more structured than what we now see in Doré. And I'm thinking, Slate Communications itself. And I'm thinking another example is the extradition Burns. I think the extradition case. Anyway, there's been cases where this has happened. So I don't think it's an impossibility. That said, I think there's a best of both worlds here where the way what Vavilov tells us is that, again, an administrator's reasons won't need to be perfect. And so we might expect them or want them to stay within the structure of the Oakes test. But we aren't going to expect them to necessarily reason like a lawyer, but we may want them to direct their attention to it, show that they considered it. Again, like in statutory interpretation, show that they adopted a plausible interpretation of the objective and the means to get there. This, again, it may be a bit burdensome, but I think it's the price of doing it. And again, I don't necessarily think it's the impossibility it was made out to be in Dore.
Carmel, unless you have anything you want to add, just building off of that, Mark, it strikes me that this kind of next question fits perhaps quite well within the research that you're doing in terms of administrative review or judicial review rather, within the context of the prison systems. And so I wonder what might happen under this kind of framework that you're proposing, where legislation expressly empowers an administrative actor to limit charter entitlements, which I think is it's patently obvious that happens within the correctional institute context. But the claimant doesn't actually challenge that legislation. They only challenge the particular exercise of the administrative authority. So kind of building off your last answer, how do you think the framework fits within those sort of circumstances?
Yeah, I think, well, this is a very live issue because a very similar question, maybe the actual opposite, but a similar question was just raised in the Safe Third Country Agreement decision that's now on appeal to the Supreme Court. And so the question is, where's the source of the constitutional problem? More likely than an express provision, this is a hunch, but I'm going to guess that more likely than an express provision infringing charter rights, you're going to just have a wide discretion that isn't expressly infringing those rights, but that in many cases may lead to that. And in other words, there's not enough guardrails to guard against an unconstitutional decision. In that case, we would think, I believe, and this is something that Slate says, that the challenge should be to the decision, because we can't be sure whether or not the legislation facially actually allows this to happen, but we do know that the decision is at least plausibly unconstitutional, and so we might challenge it. Where there's an argument where that the legislation, I think, is unconstitutional, then I think the object of the challenge is to the legislation. And this, I think, if I'm, Slate was a long time ago, but these basic principles were laid out in Justice Lemaire's opinion there, and I think they're just as good now, and I think it's basically what the Federal Court of Appeal applied in the Safe Third Country Agreement too.
Fantastic discussion. Thank you so much. So we have a few questions that have come in online. We're also going to open up to the floor as well for some questions. So if you've got some curveballs, get your wind up ready. So thank you so much, Carmel and Mark and Jonathan and Chris for that great discussion. So this maybe builds a little bit on the question that was just asked, which is, we didn't get Dore out of nothing, right? There was a path that led to Dore. There was a perceived deficiency in the framework that required Dore as an alternative to Oakes. So sort of thinking about, obviously Dore gets critiqued a lot, but in defense of Dore, there are reasons why it exists. One of them is that in an administrative decision, the constitutionality of the underlying statute typically is not being challenged. It's not in question. What's in question is a specific decision made under that statute. So doesn't that in itself require, a different framework? And, to the point about the critique that Dore doesn't take into account a pressing and substantial objective, how do we account for that in a case where the statute isn't in question, it's a decision under the statute?
I can take a stab at that. I think the setup of the question shows why this isn't really much of an issue. And I think the way I'll put it is, even though the statute isn't under attack in a typical Dore challenge, what is under attack again is the administrative decision. And once we've say admitted that the decision infringes or engages charter rights, then the question is, I think, whether or not the decision maker through his or her reasons has shown that the decision is a necessary flow from a constitutional statute. And if the decision maker can't do that through her reasons in the confines of the Oakes test, then there's a separation between the decision and the statute. And when that tie is cut between the statute and the decision maker, that's when the decision is unlawful. And so I see the statutory objective playing a role here in controlling what will constitute a decision, a justified limit by an administrator operating under otherwise valid legislation.
Thank you. Carmel, did you want to add anything to that?
I mean, I think I would just add that is piggybacking on that again, like that's the issue of the rational connection, that it's, you know, for example, in the transit cases where it's advertising on a transit, yes, like having a safe and welcoming transit might be the statutory objective, but is the decision at issue, is that connected to that? Is this the advertisement that you're trying to prevent from going onto your buses, is that actually connected to providing a safe and welcoming transit? And I think that's kind of where like a rational connection still comes into play, even though we're dealing with the decision and not the underlying statute.
Thank you. Another question here, one of the challenges when we talk about administrative decisions is it sometimes blurs the fact that there's a huge diversity of what those decisions look like in the context in which they're made. It's not like there's just one administrative decision, right? And so do we need to account for those differences? I mean, there's a huge spectrum between, say, what Justice Lowers in ET refers to as line decision makers. So someone in the field making a discretionary decision on the spot versus, you know, a very sophisticated administrative decision maker or tribunal operating in an adjudicative function. And so I think that sometimes gets blurred when we talk about administrative decisions generically, as if they're a monolithic block. What work needs to be done in parsing out an approach to take into account that spectrum?
This is a perennial problem. It's a real issue. I'll just say two things. I think the first is that Doré completely elides this because its justification, again, as I mentioned, for deference is that, well, expertise in policy matters, which may or may not exist. That's the sort of voce part of it, may or may not exist. That transfers over into constitutional expertise. This, again, I think involves a certain vision of administrative decision-making. That's maybe the labor board, and maybe it's the Human Rights Tribunal. But this epistemic justification clearly does not exist in what Justice Lowers would, it doesn't exist across the board, shouldn't be assumed across the board in frontline decision-making. And you know, certainly what I'm studying and what I'm writing about in my dissertation is in the carceral context where this assumption just doesn't make much sense. So that's the first thing. I think the second thing is Vavilov points this out that there's this spectrum of decision making, all sorts of different kinds of decisions, and the contextual constraints that Vavilov sets out change the intensity of review depending on the situation. So in some cases, the text might bind more strongly. In other cases, there's a precedent on point that the decision maker has to address. The point is that depending on the context in which the case arises, we'll see some differences in what will constitute a demonstrable justification. So I think we have the tools to manage this. Again, no law of judicial review is going to be perfect on this because it's a generalist court reviewing specific decision-making acts. But I do think that there are better and worse ways to get at this. And I think Vavilov does a better job of it and might be a good place for us to start in looking at Section 1.
Mark, did you want to add anything to that one, Carmel? Okay. All right. Well, let's take some questions from the floor. And just for brevity to streamline things, and also because I need to repeat it for folks watching online, if you could just try to keep your questions as brief and succinct as you can. But does anyone have any questions? Yes.
As you were just speaking there, problems with applying, let's say, I'm not going to say that's a problem, but just applying things to a case. just to quickly, we were just speaking about this, I haven't thought about this at all, but what's the difference between, we say there's no problem to apply oaths to a police officer, actually, so what's the difference between a police officer and a school board saying, you've got to take this class for a municipal official, building official, saying you've got to do this or that, or compromise, what's the difference?
So the question is, what's the difference between Oaks applying to a police decision versus Oaks applying to administrative decisions generally?
Well, the police decision, I'm less sure, but I'm not sure about what the framework is there, actually. Is it Oaks? They just apply Oaks to?
Well, I'm saying a police officer can infringe on rights.
Yeah.
Oftentimes that's criminal law.
Yeah.
And so we apply that to that, maybe then there could be decision making with discretion.
Yeah.
So what's the difference between that and the principle? Between that and the other decision, administrative decision making? They either have their authority from the common law or from statute. The delegated decision makers will invariably have their perspective.
Well, I mean, I guess that's maybe the so what is what my point is that, you know, like the connection, just the simple fact that the decision occurs under a statutory grant of authority doesn't mean that I don't necessarily think it leads to the conclusion that Oaks just doesn't work for some reason. I think, again, it has to be shown that the decision flows from the statute and is demonstrably justified limit on the right that's authorized by the statute. But once that connection has been shown, I don't see much of a difference. There may be differences on the edges and in hard cases, but not, I don't think, in the general run.
Good question. Any other questions? Yes. Yes, sorry, Professor Major. Yeah. Oh, we've got a mic. Perfect. Perfect.
Well, thank you all for wonderful presentations. This is the question that was in the back of my mind, the first panel we had to start today, and the challenges are numerous. Just going to try to be specific though, and I'm not going to kind of continue to go on and on. There's lots of thoughts here but I have a question for you, Mark. We were talking about decisions where there isn't a record, or there isn't a set of reasons given as you suggested looking at it. Now, there are two parts to this. First, I think that Vavilov does kind of signal a preference to want to focus on the reasons for making a decision. It does also recognize some of these situations where there is no reasons provided, where they say then we'll focus on the outcome, right? I think paragraph that's mentioned there. So do you see that potentially being applicable, crossing over to right, and how? So that's the first part. And the second part is, I thought, well, municipal councils, obviously, this is like a classic example, which is gonna, something that the Supreme Court has tried to figure out. But what you're suggesting, it kind of sounded like a municipal council will have to establish some kind of special committee to review all their bylaws for constitutional compliance. Is that the kind of cost that we think should reasonably impose upon those citizens?
Yeah. So we have first about the outcome versus the reasons. And then we have the municipal bylaw having to establish a special, okay. So yes, that in the latter part of Vavilov, it does say that the record, so again, we want reasons, but as a matter of procedural fairness, we may not always have reasons, number one. Reasons aren't always required, but where they are, we have that as our priority and our focus, but where those aren't provided, we can look to the reasons. Now, I will say, I think that paragraph, the court hedges a bit because it says, the review, I'm going to paraphrase, but I think it's that the review may necessarily look more towards the outcome. But in a number of the post-Vavilov cases, and some of them, they're still looking to the record, which will always have to exist. Otherwise, if there's no record, then the decision is immunized from review. It's sent back. So we need to see the record, and we need to be able to see some line of something, some line, a logical line through the record that leads to this outcome. The outcome will take on more of an importance there because I think we're gonna have the outcome on the paper or in front of us, and then we're gonna have to look and try to see in the record if we can get there, and it's gonna take judicial judgment. But I don't read that part of Vavilov as necessarily foreclosing looking at process of reasoning that's discernible through a record. I think this is just going to be an inevitable part of decision making in the modern administrative state. Okay, for the municipal bylaw infringing the constitutional right. No, I don't think I can be prescriptive and say that because you know, the real politics of it is that that's just not going to fly. And I don't even think it's required by the law necessarily. What I do think is required is some indication, again, that there was a consideration of the rights at play. There could be a special committee, but I don't think the law of judicial review can be prescriptive about that or should be prescriptive about that. I think, again, there are going to be many cases where this can be discerned through the record. Sometimes these decisions are made by one staff member operating in a municipality. That's a different kind of decision. Sometimes it's made in municipal committees where there are reports filed by staff and the staff reports flesh out the record. We can look to that. Lots of tools, I think, but I wouldn't want to be prescriptive in that sort of way about what's required.
We have a question from Justice Binney. No pressure.
Yeah.
Size of the administration. And the number of decisions buying officials and so on. It's the time that we took service for the example of attack. Of course, they did that, but it's the more staff with people who make these kinds of recommendations. Not burden the courts. Make the court accessible, cheaper, faster.
So I'll just repeat that just in case the Zoom mics didn't pick that up. So in light of the growth of the administrative state, is it appropriate to follow the example, say, of Quebec, where there's a separate regime specifically to deal with some of these issues so as not to overburden the courts?
You want it?
Sure. I mean, I don't really have much familiarity with that, but I think it sounds really good. And it sounds like it would be a very useful process. If you have something more substantive.
Okay. Yeah, I think it's, you know, what the way the TAC operates and the administrative justice system in Quebec has a lot to say for it, for the reasons you point out. I think as so long as there always is a prospect of review in the superior courts as a matter of the Constitution, as a matter of reality, I don't see the problem with that. It may be better than what we currently have in the other provinces. I'll just point out, I think one, from the law of judicial review perspective, one issue that has arisen is how we stacking standards of review. So TAC reviewing a decision maker, Superior Court reviewing the TAC. How do we stack the standards of review so that we're not leading to double deference or sheltering things from review? But Vavilov solved some of those problems with the statutory right of appeal holding. And so it might not be an issue anymore, but I think it's something, you know, just as a broader point, administrative justice reforms are best done by the legislature rather than courts acting in the common law mode of reasoning. And I think more provinces could do well to look to this province and to others that have legislated standards of review and have done some work to try to clean this up from a legislative point of view.
Yes, Joel. We'll just get the mic over to you.
Yeah, thanks. Mark, I think you premised a lot of your concern on the expansion of the administrative state. And so I wonder if a demand of adjudicators to spend more time on the practice review, if you think that's a solution, doesn't reify the same kind of issue of asking the administrative state to deal with its own issues by adding more to itself. And it sounds to me a little bit like you're proposing a procedural solution to an institutional problem. I wonder if you think those your so-called argument.
So just to paraphrase, in light of the fact that the administrative state is already burdened, does requiring more correctness review not add to that burden?
Yeah. This is a huge question. Thank you for asking it. I think it's very important. I think the first thing to note is that, again, we're talking about a layer of decisions, constitutional decisions, and one part of that layer would be the scope of the right that would be reviewed on correctness review. So in the run-of-the-mill case, the presumption is reasonableness review. The vast majority of administrative decisions are reviewed on the reasonableness standard. That follows from Vavilov now. So I'm not too worried about the efficiency problems that would arise from this proposal. Now, the more striking problem I think you pose is well, we're just going to be adding now layers of procedural protections to ensure that constitutional rights are upheld, or at least to limit the extent to which they're put at risk. I think it's a fair criticism, but I think this is. If the law of judicial review, if what the common law courts and what the Supreme Court says is taken seriously, then I think what Vavilov says is that the burden's a bit higher. And that's I think the way it must be then, as a matter of law, because decision makers have to abide by the law. Now, one problem, as I just pointed out, is that the solution I propose is not going to be a panacea because the law of judicial review isn't. It's one tip of the iceberg of constraining administrative power. We would do very well if legislatures took more of an interest in this. If we had a more robust Statutory Instruments Act at the federal level, reviewing regulations, if we had more legislatures adopting wide-ranging statutes governing this, I think that would be a much better solution. And that's where the magic is, I think, in that institutional combination of responses. But given that we're talking now just about the law of judicial review, I think we have to try to synthesize what's going on with DORE with what has come after it and with Section 1. And if that means a higher burden, I don't think that's a problem necessarily.
Yes, at the very back. Brian's getting all the steps in today.
Hi, I'm Edward. This is a question for Mark. You mentioned about Vavilov, where in the absence of reasons, we need to look at the record, and you mentioned about the 2W case, and about especially I want to ask about the 2W case in DC where members voted. I wonder, well, there's two parts of this question. I wonder first, do you think that was the delegation to the membership vote? Right, because if you're thinking of it, the legislature, the body, the legal body as a whole, right, to self-govern, and if you think about it, the whole of the body demonstrates the will of the body. And second, what the price of the delegation should be. Of course, you mentioned that just to bind to the constitutional issue is not sufficient, which I agree, but let's say if they didn't, for example, if they held a session, dialogue requiring arguments on both sides, would that be sufficient if they hold the vote afterwards, for example?
Yeah.
And sorry, Mark, I'll just again try to paraphrase that. So in the context of Trinity Western, but also more generally, what are the implications of an administrative decision being based on essentially a popular vote? Is that fettering discretion? I know some of the lower courts talked about that. Basically in the alternative, what is the best way to deal with that? Because there will be some decisions that, come out of those sorts of votes.
Yeah, the delegation, I'll start with the delegation point. I think it's very interesting. I'm reminded of a case, the initiative referendum. There's a referendum case in Manitoba. It's a Judicial Committee of the Privy Council decision. And, the Manitoba legislature adopted a plebiscite, and this was struck down by the Privy Council as an abdication of the legislative power. Different kind of case, but here we have an administrative decision maker that has delegated power to the body, to the membership to decide. I don't think that in itself is a problem, because I think so long as that power exists within the statute that's been granted to the administrator, the power that's been granted to the administrator, I think that's not a concern from the law of judicial review's perspective. And really, no, I don't think nor should it be, because decision makers all the time engage in consultations and to inform decisions. Now it's a different question whether that fettered their discretion, and I don't want to spend the time going into that right now necessarily, but I think that's that's a separate problem from whether or not the delegation as such is wrong. So in terms of the price of the delegation, again, I don't want to be too prescriptive because it's going to depend on the issue at hand. Like this is what the contextual constraints in Vavilov point to. And, it's going to depend on the situation at hand. It's going to depend on the nature of the problem that the administrator is asked to solve. It's going to depend on the submissions that are fed into the process. It's going to depend on the governing law. But in this case, we might expect that if it was at the venture meeting and it was discussed and the issues were raised and balanced in an appropriate way through the record, if the court can discern that through the record, then I think that's a better way to go than just asking if they were alive to it. And I think as Carmel mentioned, there may have been alternatives that could have been pursued and that weren't. And so from that perspective, if those alternatives are considered or looked at or and depending on the case are there on the record, then we might think the decision is justified. But we can't really know just by saying that the decision maker was alive to something.
All right, and
Yes.
sorry, yes, Carmel, please.
Yeah, I mean, I would just say that I don't think, I think the referendum could have been used kind of, as you were saying, as a consultation. I don't think that it should have been used as the decision in and of itself. I think the benchers needed to have had a discussion after the referendum and say, this is what the members think, and then how do we then make a decision based on that, because they were the ones who were tasked with making decisions. And then I mean, I think we don't need to get into the fettering of discretion, but I don't think that it's sufficient, especially when you have minority rights at stake, to essentially put them up for a majority vote. And I do think that the benches really did need to do a lot more work kind of in that context. Yeah.
Wonderful discussion. And so last question here, a good one I think to end on is, why does any of this really matter? For the Canadian people? Like, obviously it's an interesting discussion for those in administrative law and those who spend Sunday evenings reading the Sunday Evening Administrative Review, which I will want to put a plug in for. It's an incredible newsletter that Mark Mancini does for those that are interested in getting caught up on the week's administrative law. But in all seriousness, why is it important that we get this right for practical purposes for people on the ground? And I would also invite Jonathan and Christopher, if you have any reflections on this as well, to close on.
Sorry.
You go ahead. Yeah.
I mean, I think I often look at the quote that McLaughlin used in dissent in Cooper, but was then accepted by the majority, that this is really where kind of the rubber meets the road for a lot of Canadians, and how the government treats us and how our rights are preserved kind of in respect to decisions. And I think that if we don't get this right in this context, this is really where the average person is going to feel it. They're going to feel their rights have been infringed. And so I think in that context, it's very important that we get the test and the justification for infringement of rights in administrative law, that we get it onto a really good and solid path to preserve that in the future.
Mark?
I don't think I think well said. Yeah.
Jonathan?
Yeah, I don't have any. Yeah, if Mark Mancini doesn't have anything to add, then I certainly don't.
That's a great note to end on, Carmel. Thank you. Very well said. And will you please join me in showing our appreciation for this panel? Okay, we do have another coffee break. There's lots of, I think, muffins and refreshments, same place. So please enjoy that. But we do want to be back in the room in 15 minutes so we can start our next panel right at 3 o'clock. Thank you.
Thank you so much. I
Thank
really
you.
enjoyed your paper. I read
Thank
it.
you.
Good afternoon, everyone. I hope you all had a good break and that you're ready for our next panel. And we're going to be switching gears, as we've been doing many times over the course of the day, this time to the relationship between Section 7 of the Charter and Section 1 of the Charter. And we have two wonderful panelists and a wonderful discussant for this panel. We have, first of all, Professor Deborah Hawk, who is an assistant professor at Queen's Law, who will be joining us virtually. We have Professor Mary Sharif, who's an associate professor at Robson Hall at the University of Manitoba. And we have Professor Janine Benedict, QC, who is a faculty member here at the Peter A. Allard School of Law. And Professor Sharif will be speaking about the relationship between Section 7 and Section 1 through the lens of the issue of medical assistance in dying. And Professor Deborah Hawk will be speaking about that relationship between Section 7 and Section 1 through the lens of Canada's prostitution-related laws. And we'll start our discussion with that. So I hand over the floor to Professor Hawk. Thank you so much for joining us.
Unmuting myself. There we go. Thank you to Derek and to Brian for inviting me to participate in this year's symposium. I was grateful to have an opportunity to think more about the role of Section 1 in relation to Section 7, something that I have wanted to do for a long time, but haven't actually been able to make time to do. So thank you for giving me the impetus to do that. In contrast to some of the observations in particular from today's first panel, I'm going to suggest actually a greater role for Section 1 in Section 7 cases because of the current approach that's taken to Section 7. And I think I'm going to also suggest, or my conclusions are, that there needs to be a Section 1 analysis that is specifically calibrated to the Section 7 case. And rather than suggesting that my overall conclusions would apply to Section 1 more broadly. And again, this relates to how Section 7 is now being interpreted and applied by the courts. So before I begin, I just want to say something on a personal note. I had planned to join you in person, and unfortunately, that virus that's going around finally found my family this weekend, and me in particular. And while I am joining you remotely, I'm not feeling 100%. And this will not be my best at bat. And for that, I apologize. I have a lot of ground to cover in a short period of time and a brain that is not, unfortunately, entirely cooperative. So I say all of that just to ask for your patience at the outset, because this has been a more difficult process than I anticipated. So my paper revisits the analytical distinction between Sections 7 and 1 of the Charter in the context of Canada's new criminal commodification offences enacted in 2014 in response to the Supreme Court's decision in Bedford, and in the context of constitutional challenges to those laws based on claims that they violate sex workers' Section 7 rights. So the Supreme Court of Canada's decision in Bedford marked a turning point in Canada's legal approach to the commercial exchange of sex, but it also marked a potential turning point in the approach of constitutional challenges involving Section 7 and Section 1 of the Charter. So in Bedford, then Chief Justice McLaughlin highlighted the analytical distinction between Section 7 and Section 1, suggesting a renewed role for Section 1 in Section 7 cases. So I refer to this quote and the surrounding language in the decision as Justice McLaughlin's invitation to revisit the very limited role played by Section 1 in Section 7 cases up to that time. And many of you will be aware, hearkening back to the motor vehicle reference case, courts have regularly suggested that Section 1 has a very limited, if any, role to play in Section 7 cases. And scholars have pointed to the fact that the proportionality analysis under Section 7 is quite similar to the proportionality analysis under Section 1, and that too suggests that Section 1 really doesn't have a role to play in Section 7 cases. But here we have what I refer to as Justice McLaughlin's invitation. There are a couple of reasons why I suggest that we need to revisit the role of Section 1 in Section 7 cases. So as Justice Binney reminded us earlier, the scope of Section 7 is much broader than was originally contemplated by its drafters. But what is required to establish a violation of Section 7 post-Bedford is also arguably much narrower, in the sense that following the Bedford decision, courts can and do approach Section 7 in a highly individualistic way. In Bedford, the Supreme Court held that it is sufficient to establish an infringement of the right to life, liberty, or security of the person of one person. In evaluating whether the rights deprivation in Bedford accorded with the principles of fundamental justice, the Supreme Court there held that a grossly disproportionate, overbroad, or arbitrary effect on one person was sufficient to establish a breach of Section 7. So alongside this highly individualized approach to Section 7, the Supreme Court in Bedford confirmed that competing interests are not relevant to the Section 7 analysis. And you see that as the first takeaway from my article. The current approach to Section 7 means that courts do not consider any policy relevant interests, rights, or values other than those of the individual, possibly hypothetical rights claimant in the Section 7 analysis. So while the Supreme Court of Canada in Bedford pointed to the analytical distinction between Section 7 and Section 1, and they clarified the Section 7 analysis in a variety of ways, they did not explain whether or how the Section 1 analysis would also need to be recalibrated to respond to this shift in Section 7. So in my paper, I suggest that one of the analytical distinctions that might be drawn between Section 7 and Section 1 would be to tease apart each of the law's purpose, which we know is relevant for the PFJ analysis under Section 7, from the pressing and substantial goals of the overall policy or legislative scheme. Apologies. So teasing apart a particular law's purpose from the pressing and substantial goals of the overall policy or legislative scheme of which it forms a part, and the public interests that they aim to further, both individual and societal. My article makes a very straightforward point. Without meaningfully attending to Section 1, Section 7 challenges to criminal laws enacted in areas of highly contested public policy, courts will evaluate constitutionality without considering individual or societal interests directly relevant to Parliament in making legislative choices as between and among competing and conflicting interests. Stated this way, evaluating the constitutionality of criminal laws based solely on whether they violate one potentially hypothetical person's right to life, liberty, or security of the person, and evaluating the question of whether the infringement fails to accord with the principles of fundamental justice, with reference only to the objective of the impugned offense taken at face value, may effectively constrain Parliament from ever using the criminal law in circumstances where a range of individual and societal interests are in tension. So there is significant disagreement within Canada and beyond over how to contend with the commercial exchange of sex. Prostitution policies globally generally reflect a choice between and among often divergent and sometimes conflicting values, interests, and rights. So while Canada's current approach to prostitution is often described as an example of an abolitionist policy model, in introducing Bill C-36, then Justice Minister MacKay referred to it as a uniquely Canadian approach. This uniquely Canadian approach reflects an effort to balance the ongoing safety interests of continuing adult sex workers specifically identified in Bedford with a range of other individual and societal interests in the context of existing Canadian criminal and constitutional law. Prostitution policies regularly employ criminal laws to pursue their aims. The Protection of Communities and Exploited Persons Act created 4 new criminal offenses. Prostitution policies often also, as I mentioned, reflect choices between and among divergent values. So Canada's current prostitution policy, and including in particular this, the Protection of Communities and Exploited Persons Act, was developed and enacted in direct response to the Supreme Court's decision in Bedford. So alongside the criminal offenses, the new legislative scheme included provisions aimed at ensuring that sellers were not precluded from taking the specific measures that had been identified in Bedford as having the potential to reduce their risk of experiencing violence while engaging in prostitution. Those specific measures included selling sexual services from fixed indoor locations, hiring persons who may serve to enhance safety, and negotiating the conditions of sale in public places. So lawyers and legal scholars have consistently suggested that the new commodification offenses infringe sex workers' rights in the same ways and for the same reasons as the offenses found unconstitutional in Bedford. Shortly after Bill C-36 was introduced, more than 220 concerned citizens and members of the legal profession wrote a letter to the Prime Minister expressing the opinion that the criminal laws enacted by PACIPA were unconstitutional. To date, the constitutionality of some of the commodification offenses has been considered by Canadian courts in at least 7 different cases. You see 8 cases referred to here. The most recent is the Ontario Court of Appeals decision in NS, reversing the earlier decision noted there from the Ontario Superior Court. So all of the commodification challenges involved criminal charges laid under the material benefit procuring and advertising offenses. In none of these cases has anyone who themselves exchanged sexual services for consideration been charged, nor is evidence from any such person reflected in the reported decisions. So in all of these cases, individuals were charged under those 3 offenses, individuals who provided services, if you will, or who might be termed pimps or managers. And in each one of those cases, they argued that the offenses pursuant to which they'd been charged were unconstitutional on the basis that they violated sex workers' Section 7 rights. And in every case, the question of constitutionality was argued based on reasonable hypotheticals constructed to demonstrate an infringement of sex workers' constitutional rights. So these commodification challenges demonstrate the highly individualized approach to rights adjudication post-Bedford and how this approach foregrounds the individual interests of a particular individual, potentially hypothetical rights claimant. So in each case, the court was asked to determine the constitutionality of the impugned offenses by evaluating whether a Section 7 right had been infringed and whether the rights deprivation accorded with the principles of fundamental justice based on the circumstances of a hypothetical sex worker. So as I've explained in an article that's forthcoming in the Alberta Law Review, the use of this device allowed the courts to adjudicate constitutionality on narrowly constructed hypotheticals where no exploitation or harm was experienced by adult sex workers who voluntarily engaged in sex work, and no evidence about the circumstances of the very victims or complainants in the cases before the courts was heard. So courts evaluated whether a Section 7 rights infringement occurred and whether that rights deprivation accorded with the principles of fundamental justice with reference only to narrowly construed hypothetical circumstances, and in some cases, expert testimony about the impact of criminal laws on continuing voluntary adult sex workers. So the use of reasonable hypotheticals here illustrates how Section 7 obscures any of the experiences or interests or rights or values beyond those of the hypothetical rights claimant, even in cases where as is the case with these laws, those other interests or values or rights were directly relevant to Parliament in making a policy choice in this highly contested policy space. So let's go back to Justice McLaughlin's invitation then. Because of the shift in Section 7's analytical framework and the effect that it's had in particular in these hypothetical cases, towards highly individualized rights adjudication in the absence of any consideration of or evidence about potentially conflicting societal or individual interests, if those interests are to matter at all in evaluating constitutionality, it has to happen at the Section 1 stage. So the Supreme Court acknowledged that Section 7 and Section 1 were analytically distinct, but they didn't specify how the Section 1 analysis might need to change to respond to the change in the Section 7 analysis. So here I've underlined the three strands that I think could be usefully teased apart. And in the paper, I do so with regard to the new criminal commodification offenses because, including in the Ontario Court of Appeal's recent decision in NS, the courts are, in fact, starting to tease these apart already. So the three are the law's purpose taken at face value, which is relevant to the PFJ analysis, the pressing and substantial goal of the law, and that is, in a sense, a contextualized look at the law's purpose itself, so understanding the overall policy in which that law was enacted, and the whole of the legislative framework in which it's situated. And then thirdly, and teasing apart from the substantial, pressing and substantial goal, is the public interest. Because one of the challenges that presents itself in relation to the commodification offenses is that we see not only individual rights situated in tension with societal interests, but we see individual rights situated in tension with other individual interests or rights. And so if we tease apart each of these, we open up the possibility for courts to better attend to the fullest possible range of interests and rights that were relevant to Parliament in enacting the impugned laws. And we open up the possibility of an analytical distinction between Section 7 and Section 1. And beyond that, I think we quite usefully could tether the Section 7 analysis to a more circumscribed approach to the law's purpose. Because what we've seen in the constitutional challenges to the commodification offenses to date is a somewhat inconsistent articulation of the legislative objectives for Section 7 purposes. And so if we tease these three pieces apart, if we attend more directly to what each of them requires, we could end up with better reasoned decisions under Section 7 and Section 1 that more directly contend with a wider range of interests and rights. So a more precise and robust consideration of the interests of not only the rights claimant, but individuals with whom their interests or rights may conflict, as well as societal interests. So while my brain is slowing down considerably, I just want to leave you with a few final comments or a final word about evidence. In Bedford, Justice McLaughlin said this: the Crown is well placed to call the social science and expert evidence required to justify the law's impact in terms of society as a whole. And I actually take issue with that comment. And I know earlier today, others have suggested that the Crown or the Attorney General or the government has the potential to generate significant records of evidence for Section 1 purposes. That's not what I've seen in the context of challenges to the criminal commodification offenses. And in particular, two things influence the Crown's capacity to generate a record of the kind of social science evidence that courts are increasingly looking for. The first, in the reverse order of what they're shown on the slide, is that some things we can't know through social science methods. So if part of the aim of the new legislative scheme around commercial sex relates to dignity and equality interests, it's difficult to evaluate or to amass social science evidence about the impact of prostitution itself or of prostitution laws on dignity and equality interests. Similarly, it is generally accepted that it is very difficult to generate social science evidence about the experiences of people who have engaged in prostitution in a context of human trafficking. And yet one of the, or some of the objectives of the new offenses relate to exploitation in the context of prostitution. Secondly, as I've argued in an article published in the Queen's Law Review, Queen's Law Journal, there is what I argue is issue bias in the existing body of social science research. So when a constitutional challenge is taken in the context of a criminal proceeding, there isn't much time to generate the record. If the entire body of existing social science research is focused on one set of interests or one set of rights or one stakeholder group, then that's the only social science evidence that's available. And sometimes, in my view, the courts aren't made fully aware of the implications of that. And so I suggest, in the context of the commodification offenses in particular, that there is issue bias in favor of the interests or rights of ongoing adult sex workers. And there is absolutely nothing wrong with having a body of social science evidence that tells us about those experiences. But when there's no evidence that tells us about the experiences of others, either who are themselves participating in prostitution, who have exited, or who are other broader stakeholders in the policy space, then that becomes problematic. And it's something about which the Crown isn't well placed to call evidence. So the bottom line is, there have been a couple of mentions earlier today as well, I think, about the idea of evidence-based policymaking. And it really is worth considering whether the Charter ought to constrain Parliament to making policy that can be supported through the kind of evidence that we're looking at when we talk about social science evidence. So that's where I'm going to stop for now. Again, apologies, that is not the smooth presentation that I would have best liked, but feeling the way that I do right now, I'm glad that it's done, and I'm grateful to you for bearing with me. Thank you.
Well, thank you very much, Mr. Hawken. That was a wonderful presentation. So if that's less than 100%, 100% must be just epic. So thank you so much. That was excellent. Mr. Sharif, the floor is yours.
Good afternoon. I just want to say thank you very much for the invitation from Brian and from Derek to be here today, and I'm very grateful to be here today, and a little intimidated at all the talks that have gone previously to what I'm going to talk about. But in any event, thank you for allowing me just to share some thoughts with you. I've got a bit of a PowerPoint slide presentation, and you'll see the title is Metamorphosis, the Journey of Seeking and Inducing through Section 7 and Section 1 in Carter and Canada. So one of the reasons why I'm here is because Derek actually asked me a question, well, what about MAID? Well, what about medical assistance in living? And so I picked up on that phrase and thought, okay, yeah, what about medical assistance in living, and called it MAIL for the purposes of the presentation. This thing is doing its own thing. Okay. So thinking about medical assistance in living, and having just recently done a lot of, and have been doing a lot of work on palliative care, and trying to determine why we don't have a right to palliative care in Canada and sort of bring that forward, I just started thinking about, okay, well, what are the challenges to medical assistance living? What is the challenge to MAIL? So first of all, palliative care, it still is the case that it's not universally accessible in Canada. That's number one. There's a description, and it actually ties, I'm not sure why that's moving on its own. Okay, maybe it's on a timer. I'll watch it. There's a description that palliative care and MAID are on a continuum of care. At least there's an argument. And what that actually means, we don't have time to go into, because there's a lot of different interpretations of that. But that language does track back a little bit into Carter, but also came up in the dialogue around assisted death in other jurisdictions, and that's where that comes from. But in any event, it's a challenge to medical assistance in living if you're of the view that as palliative care is different than euthanasia or assisted death. There's also this really interesting argument that's coming up from MAID providers, making the MAID providers and MAID proponents in terms of establishing access to MAID across Canada. And this argument is that on the basis of informed consent, and that informed consent would require one to introduce MAID to patients, who would appear to meet the eligibility criteria without actually having an express request from the patient. Okay, so that's an interesting sort of moving target at the moment and debate that's going on behind the scenes. And then also thirdly, MAID saves money, right? So with Bill C7, the predicted net cost reduction for provincial healthcare spending is $86.9 million. So it's significant. So when we get into the Carter and Canada case, and what I'd like to do is just walk through just some of the observations that I have made with respect to what might be some of the challenges to medical assistance in living, specifically stemming from Carter. So we have our plaintiff, Gloria Taylor. I'm not using that laser pointer. Are you seeing that as well? Or is that just me? It's kind of strange. Are you seeing that, Lisa? Okay, I'll hold it down here maybe. Okay, so we have the plaintiff, Gloria Taylor, who had ALS and was seeking physician-assisted dying. And that's the language used in the Carter decision. So I will use that terminology, physician-assisted dying, physician-assisted death, or PAD. The argument that Gloria Taylor made was the absolute prohibition on physician-assisted dying was a cruel choice. That's section 241B of the criminal code. Now, what's key to this argument, and when you read the case very carefully, because some people did have some challenges around, okay, why is there a cruel choice, right? Here's the description of cruel choice. Suffer until I die from natural causes or end my life prematurely in a potentially violent or dangerous means, right? And some people would say, well, that's not actually the truth. There's more choices. There's palliative care. There's other things you can do. But the point here is that the person, Gloria Taylor and other individuals, are seeking assisted death, seeking death. And that's what creates the cruel choice, because there's a prohibition to receive assisted death. So I'm drawing your attention to the word seeking. Now, what did the Supreme Court say hung in the balance when this case came up to the Supreme Court? And a caveat here, I'm really just dealing with the Supreme Court judgment, not the trial judgment, not the Court of Appeal, but some reference will be made to the trial judgment because of the evidentiary basis there. So the Supreme Court said, this is a question to ask us to balance competing values of great importance. Competing values of great importance. On the one hand stands the autonomy and dignity of a competent adult who seeks death. Again, there's the word seeks, as a response to a grievous and irremediable medical condition. On the other hand stands the sanctity of life and the need to protect the vulnerable, Okay, so the court found that section 7 rights to life, liberty, and security were infringed upon, okay? Again, look at that language of seek. Section 241B and 14, so that's the provision that said you can't consent to your own death, insofar as they prohibit PAD or PAD for competent adults who seek PAD, infringe section 7 rights, section 7 right to life, right? So being in a position where you can't obtain assisted death might threaten your life, in the sense that people who are able to end their own lives can do so, but if you require assistance at some point in the future and it's illegal, then you might take your life sooner than you would want to. That's a threat to life. Liberty is basically the non-interference with fundamental personal decision-making, and security is about a restriction over control over bodily integrity. So this infringement with respect to section 7, life, liberty, and security is all about choice. All right, it's an infringement constructed on the denial of choice of a seeker of physician-assisted death. So there's no infringement, at least in this construction, of a person who's not seeking. Okay, and here's the intensity, and this is this individualistic view of Section 7. You see this language of hostage taking. That language is associated with the situation where there was an argument made that we shouldn't really proceed with assisted death until we establish palliative care for everybody. And that was the argument about hostage taking, that you're holding someone hostage who's seeking death unless and until you actually establish palliative care. That's where that language comes from. Repugnant comes from the individual seeking assisted death who would find certain aspects of palliative care, like palliative sedation, repugnant, okay, to their individual view and control of their own bodily integrity. Using an individual as a scapegoat, again, and then the word trauma. I'm just going to move along, but there's that very strong language: hostage taking, repugnant, scapegoat, trauma. So how do you square then the question I have with the description of what hangs in the balance, right? The protection of the vulnerable versus individuals who are seeking. This is very intense language. Okay, so let's look at the provision of Section 241B. Okay, that's the prohibition against assisted suicide that the court said was most on point to this issue. We have the protection, and the court described in the trial court, and it comes from the Rodriguez case, is the description. 241B is about the protection of vulnerable persons from being induced to commit suicide at a time of weakness. Protection of vulnerable persons from being induced to commit suicide at times of weakness. So it's not just about protection of vulnerable persons, it also has this piece to it about protecting them from being induced. There's the mischief. Who would induce? There was an extra argument, or many additional arguments, but one argument was this is too narrow, right? So Canada said, it also includes the preservation of life. The Supreme Court describes this as an animating social value and says that belongs in Section 1. If you define the prohibition too broadly, you're going to short circuit the Section 7 analysis. So we're looking for a narrow, precise definition according to the court. So an observation I just make with 241B is this language of induced, that it's not just about protection of vulnerable persons generally, but also protecting them from what? From being induced, okay? So we've got two pieces of the puzzle: seeking, a person seeking, which establishes the infringement. And then the flip side, the person seeking presumably would not be induced. So the court finds when in the application of Section 7, Principles of Fundamental Justice, that it was not arbitrary, that there was a rational connection between the total ban on assisted death and protecting vulnerable persons from ending their lives in times of weakness. Now, we've already established, if we go back to the definition or the object as identified by the court, the protection of vulnerable persons from being induced to commit suicide in times of weakness. But when we look at the arbitrary analysis, and it's, there's a rational connection between the total ban and protecting vulnerable persons, we've dropped the word induced, okay? Just protecting vulnerable persons generally. So there's a focus on the who benefits from the prohibition rather than what is it, what are we targeting? The third parties who might induce, which is, obviously what 241B is looking at, right? That is who actually is penalized through 241B. The third parties who might induce vulnerable persons, that's really a different question than the question of a ban between on assisted death in an absolute manner versus protecting vulnerable. If we explored the word induced, I would argue, then this would help also maintain focus on seeking, the seeking criteria, right? Because that's a key component of establishing the infringement. And I would argue that's an eligibility criteria for assisted death. So it wasn't arbitrary, but the court found it was overbroad, that the limitation on the right. So the impact of the measure, the absolute prohibition against assisted death, is not connected to the objective of protecting vulnerable persons. And the court says it sweeps unrelated conduct into its ambit. So then I ask the question, okay, what conduct are we talking about? Right? If we're talking about 241B, just protecting the vulnerable and focusing on the who, what's that conduct? Is the conduct not referring to the inducement of vulnerable people to end their lives? So here, the way the overbroad analysis goes appears to be looking at the conduct of protecting, okay? Not mischief, but a general conduct of protecting. So what happens here? So then all of a sudden we're protecting speculative vulnerable persons as distinct from identifiable non-vulnerable rights holders. When the court focuses on the who, the inducement part or the inducement aspect of it, or that consideration, also goes over into section 1. And then in terms of what conduct's wrongfully swept up, what conduct is that that's captured by 241B? Is that the conduct of seeking, or is it something else? And I think it's about accessing. So can it be justified, the infringement? Well, we know it's only in a rare case when there are competing societal interests that are themselves protected under the charter. According to the court, that kind of a restriction on rights might be proportionate. So here, step 1, does the law have a pressing and substantial object? Court said very easily and very readily, yes, it does. Didn't restate the object at the beginning of section 1. And then could it be the infringement be justified? Well, we know that it's proportionate, the means adopted are rationally connected to the objective and also is minimally impairing. And just to move along here, what has happened between section 7 and section 1 is a movement in terms of the balancing of the rights. It's, first of all, it's not, when we get into section 1, we're not talking about those seeking physician-assisted death versus that broad description that we see at the beginning of the case, sanctity of life, protection of vulnerable persons from being induced. We're not then talking about the non-vulnerable versus the vulnerable. But now when we're in section 1, we're talking about the seekers of physician-assisted death versus those who might be at risk. So now what's happened is we've gone from a mischief, which is inducing vulnerable persons, into a benefit, which is protecting vulnerable persons, and then into who is at risk if we fully realize the right. And that's where all that evidence gets basically pulled into, pardon me, section 1, to take a look at, okay, the risks. So I think I have to wrap up here. So the law, section 1, okay, thank you, finds when that analysis is done, yes, there's a rational connection. The law that bars all persons from accessing physician-assisted death will protect the vulnerable from being induced. Fine, that's rational, makes sense. But minimal impairment, no. The absolute prohibition is not necessary to protect vulnerable persons from abuse and error in the physician-assisted death regime, okay? You can use safeguards, and we have all of this evidence, and that's what happens in the Carter case. Just a massive amount of evidence with respect to the types of safeguards from all different types of jurisdictions that are permissive schemes, permissive jurisdictions that have different types of assisted death schemes. So what happens at the end? When you get to the declaration of invalidity at the end of the Carter case, we've lost inducement, this notion of inducement. We've lost the notion of seeking. Look at the declaration and I'll wrap up. You might find it implicit, but it's really not there. Section 241B and section 14 are void insofar as they prohibit physician-assisted death for a competent adult person who clearly consents to the termination of life, has a grievous and irremediable medical condition that causes enduring suffering, but focus on competent adult person clearly consents. Scope of the declaration is intended to respond to the factual circumstances of this case. We make no pronouncements on other situations where physician-assisted dying may be sought. So the only place where seeking is in that very last sentence. So when we go back to then the challenges to medical assistance in living, okay, palliative care is not universally accessible. We have this intense language associated with the work that's being done to advocate for palliative care that stems from Carter. There's an attitude there that's very negative towards it, like that it's a colorable activity. And lots of that language tracks back. The continuum of care is through the lens of MAID. And this whole idea of, because we've lost the seeking component, we've got this informed consent where people will, clinicians are being encouraged to introduce MAID to persons who have not requested it on the basis that they are eligible. And that's it.
Thank you, Therese. I'll hand the floor over to Professor Bennett to provide some comments and reflections on our two presentations. Professor Bennett.
Thanks very much to the organizers for having me as the discussant for this panel. I have to say, I'm not a constitutional lawyer or scholar. I teach criminal law, but I dabble in constitutional law, both because that's necessary to be a criminal law scholar and also because I do some pro bono litigation on behalf of women's groups and disability rights groups. And it's interesting when I reflect on sort of that body of work as a litigator, as a pro bono litigator, a lot of it is about demanding that the state take responsibility for harms that are done to women and to people with disabilities, and really trying to speak out against the privatization of responsibility for those harms. And so in many cases, and that certainly includes my 2 decades of work on the issue of prostitution and attempting with minimal success to oppose the prostitution industry, to really trying to use the charter to think more expansively about what it is we mean by rights and freedoms. And I think very much the same arguments are true about the medical assistance in dying or euthanasia issue as well. So I'm really delighted to have these 2 papers to draw on, and the really interesting and rich analytical framework that both of our speakers have presented. I'll just say, generally speaking, as Deborah has already noticed, I mean, contrary to so much of what we've been talking about today, when it comes to Section 7 and Section 1, the effect really has been reversed. The right has overwhelmed the justification, and we spend most of our time in Section 7 and very little, if any, time in Section 1. The other impact of that, of course, is that it means that Section 7 has also swallowed up other rights in the criminal law context in particular. And cases in which Section 15 or Section 2B might be part of the analysis are being kind of jettisoned in favor of trying to frame your argument as a Section 7 claim. If you're a claimant's lawyer, that makes sense because you're not really going to have to contend with Section 1. Now, I do teach the motor vehicle reference in my criminal law course. And as I read that case, it says that Section 1 can only apply to a Section 7 violation in cases of war and emergency and the like, where the justification under Section 1 is administrative efficiency or expediency. It's not any time that Section 1 is being used in a Section 7 case. And of course, we justify violations of Sections 8 to 14 all the time under Section 1, and there are also examples of Section 7 violations. So to me, it is frustrating and unhelpful to say that those broader societal considerations can't form part of the Section 7 analysis. They're not part of that balancing. And then we never get to Section 1 because it can't really apply once you found a Section 7 violation. It feels like a cruel trick, to be quite frank. Those interests have to go somewhere in the constitutional analysis. And I think that's particularly important when we're talking about claims that a law is overbroad or grossly disproportionate. The last thing I'll just say is that, from my perspective, these two issues, the issue of the laws that relate to prostitution and the laws that relate to assisted suicide, these are actually the same issues in many, many ways. And I'll give you a couple of examples. Many people have noted that it's striking that the federal government did not appeal the Truchon decision, chose instead to move to expand access to euthanasia rather than appeal that decision all the way to the Supreme Court of Canada. I think there's a very big risk that the same thing will happen with prostitution. I think the federal government is looking for an excuse to repeal some or all of those laws. And so just, expecting that whatever that trial decision might be, it will go all the way to the Supreme Court. I'm not so sure that that's the case. As Justice Binney noted in his very thoughtful remarks, of course, we also have the problem that, in these cases, it's now the findings of fact of a single trial judge. We don't have a constitutional court in Canada where, at first instance, these cases are being determined by a panel. It's a single trial judge who's making these findings of fact that are now entitled to deference all the way up. And if you represent interveners counsel, I can tell you that you're being told very clearly that you're not to try to add to the evidentiary record through the back door, particularly by crafting some kind of Brandeis brief, and you're stuck with those findings of fact and where you had no ability to influence the evidentiary record. And the last thing I'll say about these two topics, and simply I'll just say it because this is what my scholarship is about, and our speakers today didn't mention this specifically, is that both of these issues are deeply gendered issues. We can call it sex work all we like, but it's men doing the buying and women doing the selling. And yes, I understand that there are proponents of medical assistance in dying, both male and female, but to me, it's not a coincidence that many of the plaintiffs in the leading cases have been women. And I think there is a real risk of gendered notions of whose life has value and when your utility is over and when you ought not to be a burden anymore that are at issue. So it's fine to say that there are countervailing arguments and interests here, that there are individual rights claims about people who want to buy sex or profit from the sexual services provided by others, that there are people who want to access physician assistance at the end of their lives. But there has to be a space for those interests to come forward and for us to have those conversations. And so whether that involves a reimagining of Section 7 to bring those interests to the fore, or whether it requires a reinvigoration and a commitment to Section 1, I don't know. But my view is that those interests have to go somewhere. So I'll just stop there, and I'm sure that we have some questions from the online viewers and from the floor. I have a couple of questions as well for the panelists, but do you want me to go first or? Okay, all right. So I guess this is a question, these are all questions really for both our panelists, and they can take them where they want to go or decline to answer them, and that's fine too. But I guess the first question I want to ask is, what happens when the state is only weakly attached to justifying a particular legislative regime? If we have to depend on the state to build the evidentiary record, and we don't have, maybe it's a law passed by a previous government or something like that, we don't have that zeal for building that evidentiary record, and it's really coming from civil society groups, disability rights groups, women's groups, whoever. Do you see that as an issue or a problem for the kinds of topics that you're interested in?
Do you want to go first?
I could go. Sure.
Okay. It's an interesting question, right? Because if we're thinking about the Carter case, which I think about a lot, and the evidence that was before the court, the nature of that there was a lot of evidence there, lots available from disability groups and other interests and other stakeholders, right? But the nature of the way the argument, at least from what I can tell, just from this case, from the Carter case, the way it moves is that it's there to, first of all, it establishes the infringement of the right, right? And we take a very highly individual perspective on the infringement. When it moves from, and I probably didn't do proper justice because I was kind of distracted by the little moving laser target there. But in any event, when it moves across into section 1, from what I can tell from Carter, and I'm not saying that this goes across the board for other cases with respect to section 7 and section 1, I cannot speak to that. But in the Carter case, all that evidence becomes with respect to the other stakeholders, right? And all those other people who might have charter rights. There's no room in that analysis to look at what those charter rights are in terms of the competing charter rights. It's mentioned, but it doesn't happen. It doesn't take place. That's one. And then second, in terms of all the evidence then, okay, yes, some people can end up being induced. Lots of the evidence around systemic discrimination and ageism and so forth is all pulled together into risk of people who might be induced within the permissive regime, So it's about still the individual choice. And then it's all pulled into that zone. So you've got assisted death on both sides of the balance. There's no space to look at those other societal interests. And then just sort of a second piece to that in terms of what you mentioned about Trishon. Yeah, that is a good question. Why wasn't that appealed? It should have been appealed, but it wasn't. So those are my comments.
Okay, thank you, first of all, Janine, for your thoughtful comments and for the question. So I'm going to answer the question and then I'm going to make a couple of observations on your comments, if you don't mind. So I think it's a significant concern when the government that's tasked with rallying the justification is only, as you describe it, weakly attached to doing so. And I think that what it underscores is the problem when a government isn't brave enough to simply change the law if they don't agree with it, because that's what they should do. And instead, what they're doing is, in a sense, diluting the jurisprudence around really significant issues by not actually giving the courts what they need to contend with the difficult issues they should be contending with. And I think that we see that specifically in the context of these commodification offenses. We frankly, I think, have a government that isn't as committed to these laws as the prior government that enacted them was. And so they're kind of just waiting it out. But in the meantime, they're not providing that robust record that would allow a court to do what I think needs to be done, even for the pure sake of the jurisprudence at the intersection of Section 7 and Section 1, which is, how do we actually deal with highly contested policy areas under the Charter? How do we decide what constitutional constraints there are in these kinds of areas where policy involves making choices between and among interests, values, rights? And so yeah, we have a really big problem. Part of me says, Section 1 says, as can be demonstrably justified in a free and democratic society. And so the free and democratic society that we've elected, or the representatives of that free and democratic society, have decided not to demonstrably justify what they might be able to demonstrably justify for reasons unknown. But yeah, it's a problem. And I think that I don't know what we do about it unless we use that as a lever to give interveners greater powers. And that may be one of the things that has to happen. We've seen the role of interveners expanded significantly already, but maybe we recognize that they have a bigger role to play in the justification under Section 1 if the government isn't going to do its job to the fullest in justifying laws. So 2 other observations I just want to make. First of all, both of the circumstances, both of our papers talked about rights claimants who are people who want to do something that they're prohibited from doing by this legislative scheme. So they are these kind of highly autonomous individuals who want to do something. And one thing that I'm increasingly concerned with is the degree to which the autonomy interest is privileged or prioritized under the Section 7 analysis without then a meaningful Section 1 analysis to accompany it. Do we suggest that that is the only interest or the interest that governments have to prioritize in policymaking in these kinds of areas? I think that's kind of another concern we might have. And finally, this is just something I wanted to say that I didn't say when I was talking earlier, which is we need to more carefully attend, I think, to how we identify the nature and scope of the Section 7 right. In the particular context of the commodification offenses, with the exceptions and the immunity from prosecution, it is likely to be the case that under careful statutory interpretation, there is no infringement of the right to liberty, even though these are criminal offenses. So if we're then talking about an infringement of the right to security of the person, we need to ask what that right is. So what is the nature, content, scope of that right? And I increasingly refer to it as, this is a claim to a security of the person protection or right associated with the right to engage in a particular form of commercial activity or to engage in a particular form of commercial activity in a particular way. I don't see courts as having gone that far yet, but if they are prepared to go that far in respect of the commodification offenses, then when we get to the balancing at the end of Section 1, surely that right is of a different nature if it is accepted as a commercial interest. It has to impact the balancing as long as the courts are made fully aware of the dignity and equality interests, for example, that adhere in particular, as you noted, in respect of women and girls in Canada at large, and also the women and girls who are left to engage in this activity because they have no alternative. So those are just a bunch of riffy observations because my husband bought me some cough medicine that I took, and it seems to be giving my brain back some of its power.
Well, it's such a rich discussion. I wish we could continue, but that does bring us to our time for this panel. Thank you so much, Professor Hawk, Professor Sharif, Professor Benedict. Will you please join me in showing appreciation for our panel? I apologize if there were any questions we didn't get to, but please do feel free to come down and speak with the panel. We are going to have our final coffee break for the day, so please get recharged, and we're going to be back here in the room in 15 minutes for our final panel. Thank you very much.
Well, thank you very much, everyone, for sticking with us throughout the day. It's been a really, really rich and stimulating day, and we've just come to can't believe our final panel already. This panel is entitled "The Free and Democratic Society," a reference to the final words of Section 1, which have not been all that covered and developed by scholars and courts. And so it's wonderful to have some panelists to have a panel on this topic to close the day with the final section or clause of Section 1. So just to quickly introduce our panelists. First of all, we have Professor Paul Payton, QC, who holds the Thomas Lawler, QC chair in Law and Ethics at the Faculty of Law at the University of Alberta. We also have Benjamin Woodfinden, who is a doctoral candidate in politics at McGill University. And we also have Professor Victor Muniz-Faricelli, who is an associate professor cross-appointed both in law and in politics, political science at at McGill University. And so we have a really excellent panel with some very rich topics to try to engage with this concept of the meaning and nature of a free democratic society through the lens of Section 1. So with that, if it's okay, maybe I'll hand it over to Paul first, just given the, or Ben, like reverse it. Absolutely, that's fine. Ben Woodfinding, the floor is yours. Please join me in welcoming our last panel.
Well, thank you, Brian and Derek, for the invite. It's a pleasure to be here with you all today. I confess, when I saw the lineup, I was a little bit intimidated by some of the speakers, so it's genuinely an honor to be here. I think my paper is going to be probably among the more theoretical papers here today, but as an aspiring theorist, I make no apologies for that. So in Oakes, Chief Justice Dixon described what he calls the contextual element of interpretation in Section 1. It refers to the, quote, it refers the court to the very purpose for which the Charter was originally entrenched in the Constitution. The underlying values and principles of a free and democratic society are the genesis of the rights and freedoms guaranteed by the Charter and the ultimate standard against which a limit on a right or freedom must be shown, despite its effect, to be reasonable and demonstrably justified. The core of Dixon's claim here is an inescapably normative contention that these underlying values form the ultimate standard for identifying permissible limitations because they are the basic bedrock values that are the genesis of Charter rights themselves. And as has been alluded to a few times today, this ultimate standard is largely ignored by the courts and by Section 1 jurisprudence. This should not necessarily come as a surprise. The explicit normativity the ultimate standard offers makes it hard to imagine what any kind of consistent approach to evaluate these claims could look like. Courts are probably wise to avoid trying to determine what this means and how they can be used as an ultimate standard to assess reasonable limits. It could potentially give judges a wide-ranging scope by which reasonable limits could be assessed, with minimal consistency and far too much room left for judicial discretion to determine which values take precedence in determining limits in a free and democratic society. But I think we should still think seriously about how to understand this ultimate standard and how to think more broadly about the free and democratic society. In thinking about what the free and democratic society means, one good place to start is examining democracy specifically as one of the key unwritten constitutional principles that can help specify the text. The secession reference discusses these unwritten constitutional principles extensively. The discussion of democracy in secession is multifaceted. Democracy has, quote, always informed the design of our constitutional structure and continues to act as an essential interpretive consideration to this day. Drilling deeper, the court identifies what is ultimately at the core of democracy as a substantive goal, equating democracy with a few things, but among them, the idea of self-government. But what the court also makes clear is that the basic fundamental values like unwritten constitutional principles cannot be understood in isolation. They shape one another, they interact with one another. And a subtle but important point emerges out of this in the context of the free and democratic society. There are many fundamental values that give coherence to the entire constitutional order, but they cannot be understood in isolation of one another. And the way that these values interact with each other helps to clarify and specify their normative and moral content. This matters for understanding the free and democratic society. Freedom and democracy are clearly linked in that they form the bedrock on which charter values rest, on which charter rights rest, on which they're premised. The inclusion of both freedom and democracy tells us something important about the normative standards that the charter framers had in mind. One of the key claims of my argument here is understanding the way freedom and democracy interact with each other in the context of Section 1 is this idea of participation. The concept of participation helps bring together and provide substance to what it means to live in a free and democratic society. Both Oakes and the secession reference make reference to this idea of participation in their discussions of democracy. Other scholars have made similar arguments. Michael Powell has argued that we should, quote, interpret the unwritten principle as embodying a thin or procedural account of democracy tied to meaningful participation rather than a thick version imposing specific outcomes or broader obligations. We can all generally agree on the importance of democracy as a bedrock constitutional principle and constitutional value, but we disagree over the content and specification of this concept, and this is unavoidable. Democracy and freedom are what I call essentially contested concepts, and yet we're still going to have to find a way to settle or resolve disagreements over them and try and figure out what kind of specificity we can apply to them. These are what we can call the circumstances of politics that we find ourselves in. Courts could develop robust normative doctrines about the nature and meaning of democracy, But that would not mean the court has overcome the circumstances of politics. It would simply mean that the court has adopted one contestable account of democracy over another. This is why in the paper I introduced Jeremy Waldron's idea of participation, what he describes as the right of rights. I'm not going to rehash all of Waldron's argument here. I would hope that some of you are probably familiar with it, but I'll just say briefly that Waldron suggested in response to the circumstances of politics and the inevitability of reasonable disagreement over fundamental moral and normative questions, if we take our status as individual rights bearers seriously, it means we need participatory procedures to help determine the scope and content of rights. Waldron describes this as the right of rights. He's not describing it as a kind of super right, as a kind of right of rights. He's describing it as a kind of built-in implication of our status as rights bearers if we take that status seriously. This is not a democratic justification of participation. It's an explicitly rights-based justification built on a fundamental account of what rights are and what rights entail. There are two reasons why this is relevant for helping us think about the free and democratic society. And the first has been briefly discussed already. Fundamental values cannot be understood in isolation with one another. The interaction of values, fundamental values, shapes the content and the scope of these values. Freedom and democracy in section 1 cannot be understood in isolation of one another. The free and democratic society is not merely a formalistic sum of freedom and democracy. The interaction of these values shapes and modifies them both in the process. Waldronian participation is, I would argue, probably one of the better ways to think about how to understand freedom and democracy, a free and democratic society put together in the context of section 1. Second, if there are any two political concepts that qualify as essentially contested, surely freedom and democracy are top of the list or near top of the list. Participation in defining and elucidating what these terms means may be a more procedurally legitimate way to help determine their scope and their content. The question then becomes whether there is a participatory role and institution capable of helping assess and showing demonstrable justifications for limits in a free and democratic society. The conventional answer, though not without dissent, of course, is no. And I take Dworkin to be a kind of stand-in of a broader kind of view of how this works. Dworkin describes courts as a forum where decisions are made and evaluated based on principle. I'm sure you're familiar with this. In contrast with legislatures, which are a forum of policy. The distinction implies that courts are places where right should be the place that adjudicates and settle questions of principle and right, whilst questions of policy and general interest ought to be left to legislatures. In a crude sense, this is often how section 1 adjudication works. The courts determine the principles and the legislature is then left with a kind of range of options, policy options from which to pick to revise or amend legislation so that it passes. This is the way the dialogue between courts and legislatures has been understood by scholars like Hogg and Bushell, for example. This division of responsibilities makes sense if we understand the courts to be the place where reasoned arguments take place, whereas legislative decisions are based on aggregated preferences that are not necessarily rational or reasonable. But this argument fails precisely because it mistakenly suggests that legislatures are somehow incapable of the kind of reasoned deliberation that we would expect for someone to demonstrably justify, say, a limit in a free and democratic society. I'll keep my comments on this short, but I build and borrow heavily on Richard Eakins' account of legislative reasoning in this. Legislatures and legislation is not simply the aggregate preference of a political community. It is the product of reasoned deliberation, acting on choices towards a clear end, namely, for Eakins, the common good. Legislative reason is not simply the same as democratic or public reason. It's different. It emerges only out of an institution specifically established to enable deliberation with the intentions of producing legislation that is the result of reasoned deliberation. So legislatures can reason in a way that the demos, kind of broader population may not be able to reason with, is part of Eakins' contention. Legislatures and legislation are also capable of reasoned consideration of rights. This reasoning is not simply able to produce policy outcomes conducive to the common good. Rights are part of the common good, and reasoned legislation will be considerate of rights as well. But legislatures do reason in a specific and different way about rights. As Eakins suggests, a core of what the relationship between rights and the common good entails is rights specification in a way that affirms rights as a crucial component of human well-being and flourishing, common good, as he calls it. Legislatures do not reason about rights in the same way that courts do. Reasoning is in this sense, is in some sense institutionally embedded, and different kinds of institutions reason in different ways. The kind of reasoning that the courts engage in when interpreting and deciding on what rights limitations is not necessarily the only or even the best way to think and reason about rights. But one example of the way that legislative reasoning over rights will be different than judicial reasoning or institution that takes place in judicial institutions is that legislative reasoning can incorporate ideas of compromise into the specification of rights in ways that adversarial arenas may not necessarily be well suited for. And to wrap up, I want to leave this kind of a deliberately open-ended theoretical proposal. Legislatures can and should play a role in determining demonstrably justifiable limits on rights. What I think this suggests, perhaps even more radically, is that this entails, if we take this seriously, what it entails is a kind of epistemological pluralism. This is not the same as simply allowing assertions by legislatures to count as legislative reasoning, the kind of reasoning you could imagine taking place, say, if like the Mack truck clause had been used instead of the current text of chapter of section 1. If the kinds of reasoning that legislatures engage in on reasoning is different from the courts, the expectation should be that reasonable legislative limits will look different as well. Again, think of compromise. And recall that Ekin says that compromise plays an important role in legislative reasoning on rights. This is not something that judicial reasoning is necessarily well equipped to understand on its own terms. So the implication, if taken seriously, of this understanding of the free and democratic society and how the ultimate standard of section 1 should be understood would demand more attention to developing methods of dialogue that would enable dialogue not simply between different institutions, but dialogue that enables institutions to engage in different modes of reasoning, but in still rationable, and in the case of section 1, demonstrably justifiable ways. The claim here that participation is the best way to understand the interaction of the free and democratic society and the possibility of reasoning, assessing rights and their limitations by institutions other than courts is one that could potentially help us reimagine section 1 in a way that is potentially more procedurally legitimate and a more honest and fulsome reading of the text. Thank you.
Thank you so much, Ben. Professor Payton, the floor is yours.
Oh, you brave souls. You get to be here for the final presentation of a very long and very interesting day. And I'm going to do what I can to liven it up a little bit and not speak about high theory, but rather to talk about the legal profession and the independence of the bar in a free and democratic society. And I'm going to look a little internationally. I have been known to live life in comparative perspective, and I'm going to continue that theme today by talking about 3 very recent reports, one in BC, one in the UK, and one in California, that all slam the legal profession for the way it is or is not serving the public interest in a free and democratic society. So stay tuned. I've got a few introductory comments that I want to make before I begin with a note of thanks. And first off, to recognize Justice Binney, distinguished guests, and many friends who are here. Such an illustrious group assembled, and that's a tribute, Derek and Brian, to your tenacity, to your vision, and to the importance of the subject. I can't help but also note that this is the first presentation I've done in person in Canada since the pandemic began, and it's a particular privilege to be here with and amongst you. It's also a special honor. She was online earlier on, so I doubt that she's still there with the 39 souls who are brave enough to stay on Zoom for this presentation, to be appearing on the same speaker list as Professor Lorraine Weinrib. It's 30 years since I graduated from the University of Toronto Faculty of Law in 1992. And this Professor Weinrib, there were 3 of them when I was at U of T Law, taught me con law in 1L. Though remarkably enough, not the charter. Professor Ruth Kolker was visiting at the time from the ACLU in Tulane, but I did have the opportunity to do a constitutional litigation practicum with Professor Weinrib and with Mary Eberts, which remains one of the most outstanding educational experiences I'd had. I also have to note the special pleasure of reconnecting with Professor Jamie Cameron, especially given what I'll be speaking on. When I headed the multidisciplinary practice initiative for PricewaterhouseCoopers LLP in Canada, I commissioned an expert report from Jamie that was foundational in addressing regulatory issues connected with constitutional ones that eventually helped lead to the establishment of what later became PwC LLP and the other big 4 connected firms in Canada. Jamie, it's wonderful to be here and to continue that conversation. I know, however, that any mistakes that I'm making today, then and now, are of course my own. Brian and Derek were kind enough to extend an invitation to me in February to present on the relationship between the Free and Democratic Society of Section 1 and the statement by Mr. Justice Esty in AG Canada and the Law Society of BC. Justice Binney, to your theme about what happens in BC seems to infect everything else. That was a case in 1982, popularly known as the Jabour case, that the independence of the bar from the state in all its pervasive manifestations is one of the hallmarks of a free society. Now, as many will be aware, in that case, the Law Society of BC initiated steps to discipline Jabour, a lawyer whose advertisements for his practice, what is it about lawyers and advertising, were alleged to have contravened Law Society rules. Jabour sought a declaration that the rules offended Combine's legislation. The Law Society argued in response that the legislation did not apply to it because of the provincial legislation enabling the Law Society itself. So to the point about our law societies, is regulation of the profession something that is organically drawn or delegated in terms of legislative authority? This is one of the theoretical questions I'll be addressing in the final paper, but I'm not going to touch on that today, although I believe Victor will. Justice Esty held that the provincial legislation protected the Law Society from federal anti-monopoly provisions. And the oft-quoted passage that Derek and Brian invited me to consider comes in the description of reasons a province would enact legislation for the self-regulation of the legal profession. And forgive me for quoting it at length, but it's worth noting for purposes of this presentation. Justice Esty wrote, "The independence of the bar from the state in all its pervasive manifestations is one of the hallmarks of a free and democratic society. Consequently, regulation of these members of the law profession by the state must, so far as by human ingenuity it can be so designed, be free from state interference in the political sense, with the delivery of services to the individual citizens of the state, particularly in the fields of public and criminal law. The public interest in a free society knows no area more sensitive than the independence, impartiality, and availability to the general public of the members of the bar, and through those members, legal advice and services generally. The uniqueness of the position of the barrister and solicitor in the community may well have led the province to select self-administration as the mode for administrative control over the supply of legal services throughout the community." Now, there's a reason I'm quoting that at length, because it invites discussion of the regulation of the legal profession, but more broadly, the regulation of the delivery of legal services, who delivers them, how, and where the public interest is engaged. And for the reasons I'll come back to, the three reports that I'll be citing, two in April of this year, one from last December, all re-engage those questions. In a 2005 Canadian Bar Review article, Roy Millen argued that the independence of the bar should be recognized as an unwritten constitutional principle, a foundational norm necessary for the maintenance of freedom. Millen noted that Justice Esty's passage was quoted with approval by Justice Iacobucci in the 1991 Supreme Court decision in Perlman and the Manitoba Law Society Judicial Committee. That was a challenge to the section of the Manitoba Law Society Act providing for the award of costs of an investigation against a lawyer. Now, law students still in the crowd, stay tuned. Here's creative argument at its best. Perlman had argued that the provision created a reasonable apprehension of bias because the benchers on the committee had a pecuniary interest in the outcome of the case. Essentially, the costs award from Perlman himself would generate revenue for the Law Society, slightly reducing the fees charged to all Law Society members, including those on the discipline committee. This made its way up to the Supreme Court of Canada. Justice Iacobucci actually analyzed Perlman's claim under Section 7 of the Charter, holding that the principles of fundamental justice depend upon the context in which they're invoked, which in Perlman's case was the self-regulation of the profession and thus the independence of the bar. In the end, Justice Iacobucci concluded that there was no reasonable apprehension of bias on the part of the benchers. Nice try, though. Millen writes that Justice Iacobucci, quote, did not explicitly state that the independence of the bar is a principle of fundamental justice, but he did consider the principle an important contextual factor in determining the application of the principles of fundamental justice. And Justice Iacobucci quoted with approval an extended extract from a report of the Ministry of the Attorney General in Ontario in arriving at that conclusion. Stress was rightly laid on the high value that free societies have placed historically on an independent judiciary, free of political interference and influence on its decisions, and an independent bar, free to represent citizens without fear or favor in the protection of individual rights and civil liberties against incursions from any source, including the state. 20 years ago, following the successful launch of the law firm that became affiliated with PwC in Toronto, and then in 2002 in Vancouver, I took a leave of absence to explore questions of self-regulation and the future of the legal profession in light of developments that included multidisciplinary practice and what later became known as alternative business structures. My work at Stanford at that point laid the foundation for later examinations on threats to self-regulation of the profession in Canada. And that was the start of what's now been my academic exploration of these themes for about 20 years. How can we justify self-regulation when core values rhetoric has served to stifle innovation, and when claims to be acting in the public interest or to protect the public interest have too often been conflated with the self-interest of preserving an ossified profession that's resisted globalization, technology, and alternative approaches to legal services delivery that could transform access to justice for all. I told you there might be some fireworks. At root, this debate, who should regulate lawyers, or maybe let's reframe that, who should regulate legal services delivery, has been a constant over the 2 decades I've been engaging in these questions. At times, it seemed like a sea change has been coming, only to be pushed back by reliance on things like the independence of the bar as justification for rejecting reforms. Let me take another Canadian example before quickly providing an overview of the 3 reports. It was a report of the Competition Bureau of Canada in December 2007 on self-regulated professions that took direct aim at measures imposed by the legal profession's self-regulatory bodies, including the Law Society of Upper Canada, as it then was, that the Competition Bureau found unnecessarily restrict competition. The report attacked limits on advertising, outright prohibitions on referral fees, bans on multidisciplinary practices, and, for the law students in the crowd, the length of articling. The report also sought to hold the Law Society to account for restrictions on other legal service providers from performing certain tasks unless there is, quote, compelling evidence of demonstrable harm to the public. The Competition Bureau's criticism of the Law Societies was blistering and timely, and I will ignore you. At the time, I argued that the report's recommendations pointed to a paradigm shift in where to start thinking about regulating legal services. For the Competition Bureau, much as in the UK, the welfare of consumers was paramount. I argued then that events in England, in particular the Legal Services Act of 2007, could be seen as potentially heralding the effective end of self-regulation, implementing a regulatory model and structures more closely tied to government. This was not without its concerns. The 2007 Act in England had passed after a decade of debate and had many of its roots in a 2001 report by the English Office of Fair Trading, concluding that restrictions on the provision of legal services were not justified by professional rules, but were essentially anti-competitive in nature. Much has happened since then, and yet very little has changed. In Canada, we've got the introduction of innovation sandboxes, which I'm happy to talk about in the Q&A, that to my mind simply continue to entrench law society control over legal services, innovation, and delivery, despite some very suspect authority that law societies actually don't want challenged on constitutional grounds or otherwise. In various other articles and reports in the US, including over 3 years I spent as a reporter to the ABA's Ethics 2020 Commission, and currently as a member of the ABA Standing Committee on Professional Regulation, I've continued to ask whether the independence of the profession could be sustained if the profession was neither acting nor seen to be acting in the public interest. So 3 reports, very quickly, just as a bit of an introduction. One in Canada, indeed here in BC, one in the US, and one related series of reports in the UK have thrown these questions about the relationship between the state and an independent bar back on the front burner. All 3 are about the regulation of the legal profession and the independence of the bar in 3 different, but nonetheless still equally free and democratic societies. They represent real challenges, once again, to what's been seen as traditional regulatory authority, and by extension, the potential for shrinking the distance between an independent bar and the state quite considerably. The November 2021 report of a governance review of the Law Society of British Columbia, now being called the Caton Report, is a primary focus for me, and it was fairly scathing in its essential conclusion. It noted the legal framework within which the Law Society operates is not fit for a modern regulatory body, and that it hampers the Law Society's benchers in fulfilling their responsibilities. In particular, the power of the members to elect the benchers and to overrule them and stop changes to the Society's rules means, and I quote, "The Society acts more like a professional association than a professional regulator." It went on, and this is from Executive Summary, Section 1.6, the review finds that there's a lack of engagement with regulatory matters and that the Society is too involved in responding to the interests of the legal profession. Everything old is indeed new again. In California, an April 14th, 2022 publication of a blistering report by the state auditor slamming the State Bar of California arose as a result of a Los Angeles Times expose focused on the way in which LA lawyer Tom Girardi, he's the spouse of one of the Real Housewives, for those of you who are fans and might know it that way, had managed to avoid disciplinary scrutiny while, as one report put it, snarfing his client's settlement funds, which were quite considerable. The report was described as driving the nail into Girardi's disciplinary coffin, but also a well-deserved stake into the California State Bar's current discipline process. Essentially, the audit found all sorts of problems, including the real doozy, the failure to consistently consider conflicts of interest between state bar attorneys, bar staff, and the attorneys who were under investigation. Third illustration, very briefly, that I'm exploring is the 2020 final report of the Independent Review of Legal Services Regulation in England, the so-called Mason Report, and the April 2022 supplementary report he recently published. The latter is entitled, quote, "Consumer Harm and Legal Services from Fig Leaf to Legal Well-Being," which gives you a sense of its contents and aspirations. The 2020 report was entitled, quote, "Reforming Legal Services, Regulation Beyond the Echo Chambers." And in that report, Mason concluded that the legal profession's echo chamber is a comfortable and comforting place for many of its members and representatives. The reverberating belief is that all is fine, that citizens are best served by qualified lawyers, and that the world would be a better place if all providers were like them. In fact, better still, if they were the only providers. Their ideal future would have more qualified lawyers, more public funding to meet lawyers' fees in times of need, and extensive education of the public so that people and businesses could understand better why they should value and pay for lawyers and avoid the unregulated. Mason concluded, the problem with the lawyer's echo chamber is that its beliefs and opinions are shared by so few others. It matters not whether those beliefs and opinions are right. In his Wickwire Memorial Lecture in 2021, entitled Legal Services Regulation, Turning Point or Point of No Return, Mason pointed to regulatory reforms in Australia, the UK, the US, particularly in Utah and Arizona, as well as in Canada. He said, to lawyers, these initiatives are variously seen as innovative or Faustian bargain, as long overdue, or the thin edge of a wedge to be resisted. I can tell you, as the only academic on the working group supporting the Arizona Supreme Court to draft rules to implement revolutionary change in that state in 2021, I can confidently say that there and in Utah, it was the judiciary that led the way, saying to the profession, enough is enough, it's time to open the market in order to address the access to justice questions. So what's going on in all three jurisdictions? Globalization and indeed technology in particular are transforming the way in which consumers are accessing legal services and the way in which legal services will need to be regulated. BC? Well, we'll see. So it is an independent bar essential to the functioning of a free and democratic society. It may surprise many that I say yes. I am sometimes misperceived as anti-lawyer. What I am for is a legal profession that justifies its value to the public, responds to the consumer interest, and regulates in the public interest to uphold those values that Justice Esty and Justice Iacobucci were speaking of. I look forward to your comments, and I appreciate the chance to be part of this remarkable conversation. Thank you very much indeed.
Thank you, Mr. Payton. Ms. Renicelli, I'll give you the floor to offer some reflections and comments in response to what we've heard.
Okay, so I have the unenviable task of trying to bring together a paper whose speaker explicitly said, I am going to be theoretical, I'm a political theorist, then the second paper whose speaker explicitly said, I am not going to do high theory and stick to the practical. And I have to confess, because if we're going to speak about institutional conflicts of interest, that not only am I a political theorist by training, although I'm also a lawyer, I'm also very happy to have read quite a bit of Benjamin Woodfinden's work before as a member of his doctoral committee. So I am going to try to make some general comments that are interesting, I think, to both papers, because although they speak to the more theoretical aspect, they speak, I think, to the theme of the panel, which is the definition, or as I will say, the question of how we would come to define, how we would even start to think about defining the concept of a free and democratic society, and how these two different approaches to the question of what a free and democratic society is, in fact, contribute different methodological responses to the question. Because honestly, methodology is where 90% of the action is in any discipline. When you tell graduate students, and I remember when I was a graduate student and I was told to take methodology, it was not the most exciting thing in the world for me. But just like, say, procedure is 90% of a legal case, and the substantive issues, if they get to 10%, are in fact aiming quite high. The methodological question of how to define a free and democratic society is really at the heart of what this theoretical question is about. And I can imagine several ways of defining it. And I think that in Ben Woodfinden's essay, I saw at least two different approaches. And there are two different approaches that have deep roots in the philosophical tradition. One of the approaches, the one that is sometimes more familiar to us because of the great giants, classics of the Western political tradition, Jean Baudin, Thomas Hobbes, is a philosophical and analytical approach. You look at a free and democratic society and you ask, what are the necessary and sufficient conditions for a society to be free and democratic? And you do this with some attention to history as evidence, but not attention to history as authority. You can end up in very interesting places if you go down that route. For example, you can end up in the place where King James VI and first ended up when he tried to define what free was in the context of a state. He did not mean a state that promotes individual freedom. He meant a state that was unfettered by external authority and unfettered by internal bodies, perhaps including an independent bar. I mean, James famously wanted to overrule Sir Edward Coke, and Edward Coke responded, I think, quite deftly, that lawyers, perhaps not as wise in the natural reason of the state as the king, were nonetheless much wiser in the artificial reason of the law. So we can understand free and democratic from the perspective of an analytic structure. And I think that sometimes Ben Woodfinden is leaning in this direction, leaning in the direction, for example, of trying to identify those conditions in which citizens could in fact influence, act upon, deliberate directly or indirectly through the legislature about fundamental values of the society as enshrined in the document of the Charter. But also from the very start, and actually I'm going to step here for a second because I left this particular page of notes on my desk. Justice Dixon himself takes a different approach. It's not, he doesn't take an approach that is
deductive and philosophical. He takes an approach that I would characterize as exegetical, or perhaps more generally hermeneutical. He lists in the text itself the things that seem to constitute a free and democratic society. He lists, for example, respect for the inherent dignity of the person, which you can find in sections 2 and perhaps 7 through 14. A commitment to social justice and equality, section 6, section 15. Accommodation for a wide variety of beliefs, pretty much anything on section 2. Respect for cultural and group identity, section 16, 23, 25, 27. And faith in social and political institutions, which enhance the participation of individuals and groups in society, sections 3 and 24. So in that sense, rather than looking at what in the abstract one would require as necessary and sufficient conditions, one can say the free and democratic society is not entirely determined, but certainly shaped, structured, and our reasoning must begin from the historical point in which we find ourselves, which is the historical point in which that has crystallized in the Charter Instrument. Not everything goes. There were other options. There were other ways of structuring freedoms, of balancing them out against each other. There were other interests that the state could advance as important interests that may perhaps require the shaping or balancing or proportional adjudication of certain rights, but these are the ones that are here. So I think that distinguishing between those two methodological approaches, the philosophical deductive and the hermeneutical or exegetical, is one way of understanding the difficulty with that definition. I think it also applies to the question of the independence of the bar. One response of why the bar is necessary for a free and democratic society is structural, is more akin to the philosophical or deductive definition. Although in this case, it's a rebuttal of Hobbes, a rebuttal of Baudin, a rebuttal of King James. The independence of the bar specifically and the legal profession generally, following Cook, is necessary precisely because we need the rule of law to stand aside from politics, and you cannot trust those who handle politics, those who have a means-end analysis or a results-oriented, purely results-oriented analysis or a purely political analysis, to restrain themselves when they face a legal obstacle. So we need an independent legal profession structurally. It's a necessary, not a sufficient condition, but certainly a necessary condition for the rule of law and for certain features of what we would consider free. I think we could even actually borrow some of King James's understanding of free state as an unfettered kind of entity, in that we also need the law to be free because we need it to interact with other legal orders and other normative structures, not only legal, but other normative structures. But then there's also a genealogical argument. The argument that says the state did not create the legal profession, at least the modern legal profession as we understand it. In fact, it didn't even create the pre-modern legal profession. I mean, there were no lawyers famously in Athens. There were lawyers in Rome, but the lawyers in the Roman state were essentially private orators who were hired individually. There was not even a public prosecutions. If you were sanctioned by the Senate, you were sanctioned by a legislative body who prescribed you. You were not, in fact, tried in any relevant sense. But the legal profession that emerges in slightly different ways and through slightly different histories in the continent and in the British Isles emerges independently of the state. It is self-regulating in the sense that it's self-generating. It started basically as a student union. It starts as a student union in Bologna, a bunch of students who fundamentally, metaphysically misunderstand Roman corporate law and organize themselves as universitas, which just means corporation, in order to hire teachers and hold them to their contracts. And then from there, it leads to these students going to different places in Europe and basically relying on each other and citing each other. They constructed a network for themselves and then asserted authority. Most famously, asserted authority when the Pope and the Emperor juridicalized their disputes. The academic freedom as we know it was bought by the scholars of the University of Bologna, who wrote a brief from Emperor Barbarossa in his favor against the Pope, and the Pope in exchange told them, your degrees will be valid across the empire, and a bunch of other wonderful stuff that we have unfortunately lost, like, you know, they have to sue us on our home campuses, and we are protected from robbers and from tax collectors. In Britain, the process was much more administrative, but it led essentially to the same thing, a profession that organized itself, that from a historical perspective, generated its own existence and asserted itself as an authority. But then it got an enormous amount of privilege. And it got an enormous amount of privilege, which it proceeded to exploit, sometimes in good ways, and sometimes perhaps even in necessary ways, and sometimes in more nefarious ways, as outlined by Professor Payton, that essentially turn it into an entity that corners the market in a certain way. So if we go back, if we take seriously both the deductive, structural, philosophical methodology and the hermeneutic or genealogical methodologies that seem to stand against them, and seems to constrain our reason, constrain it in the sense that we don't start from first principles whenever we have to think about society. We begin from a given history and a given standpoint. We should also perhaps go back. We should go back to the generators of that very independence. We should start to look at Edward Cook's Prohibition du Roi, that case where he makes the claim of the artificial reason of the law, and maybe read it along the lines of Dr. Bonham's case about monopoly legislation in restraint of trade, and think about how these things go together and the alternatives that can emerge. So we need a richer genealogy and a richer hermeneutic in order to look at the alternatives that were in fact in place. Now, I teach in Quebec, and I've had to learn quite a bit, even though I come from a very similar legal system, a similar mixed legal system. I've had to learn quite a bit about Quebec history and Quebec civil law. And if we go back between the Conquest and the Quebec Act, we can actually see different possibilities emerging. The possibility that perhaps the legal profession is independent, the legal profession is self-generated, the legal profession ought to be guarded, but there are other things that people can do. People went to priests in taverns to solve their legal cases. People decided things on an ad hoc basis with wiser members of their towns. And the legal profession can perhaps only retain its independence, historically gained, by acknowledging that there are ways of resolving things other than law, which may perhaps lead it to reconsider its privileged position in the system. Thank you.
Thank you so much, Professor Muniz-Fraticelli and Benjamin and Professor Payton. Great cap to the day. We've got a final 15 minutes here. We're going to make it exciting, rapid fire questions. So we're going to invite both Benjamin and Professor Payton to respond to those comments. But just to add something to the mix, we're just going to invite a few questions from the audience as well that we'll just kind of collect and add to the recipe here. So any questions from the floor? Yes, Professor Newman. And we'll get a mic to you.
A question to Paul. You're speaking mainly about the issues with respect to regulation of the bar. I'm wondering what you would say with respect to other threats to independence of the bar that may come from private actors, attempts by cancel culture, for example, to act against lawyers who represent disfavored claims or causes, of which we've seen a number of instances lately. But where is the protection from that likely from, and how does that fit into freedom of society, respect of government action or
Great question. So just to paraphrase for those watching, the question was, when talking about the independence of the bar, consideration not just of independence from the state or from regulator, but what about independence from pressures from private actors? So do you want to respond to that directly, Professor Payton?
As best I can in a rapid fire notion, back Dwight to your comment this morning about cramming a thesis into 30 seconds. One of the things that I've harped on consistently is the need for lawyers and the bar to do a much better job of explaining the role of the lawyer and the bar to the public. And part of that is explaining the importance of having a lawyer to deal with an unpopular case or an unpopular cause. And I go back to thinking about actually my doctoral supervisor, Deborah Rohde's comment that everybody hates a hired gun until they need one of their own. And so in that respect, at least, it becomes a part of public education, differentiating even for law students between the cause and the client is sometimes difficult. And often those as well who have argued for cause lawyering have blurred those lines. So I think as we look at a culture that has considered lawyers privileged, hasn't always understood the role of the lawyer in the legal system, and why they might represent unpopular clients. To a certain degree, the challenges under cancel culture or present circumstances aren't any different than they've always been. And so we should be drawing on those lessons and doing a better job. I think that's ever more important in light of some of the controversies that we're seeing and where legal representation continues to be needed.
Thank you. A couple other rapid fire questions before we conclude. Yes, at the very back.
It's a quick question for Professor Payton. Given recent auditing scandals that have emerged in the UK, I'm thinking KPMG's failed audit of Brilliant, or EY, who are actually a former employer, being sued for another auditing issue in the UK. Any second thoughts on the Big Four's delivery of legal services? Can an auditor also be a lawyer?
Again, this is one of those really easy questions. I would differentiate between two issues that you're identifying. There is the question of delivery of audit and legal services from the same provider to the same client that actually was addressed in great detail before Sarbanes-Oxley and the explosion of scandal in the United States in a couple of reports that basically looked to put a firewall between audit services delivery and otherwise. I hate to be one of those academics that said, I have an article on, but I have an article on that, and I actually wrote it at the time that looked at this question of what sorts of protections are necessary in those firms. Part of my problem is that people look, and the legal profession looks at the Big Four or otherwise, as though the legal profession itself has no problems. Panama Papers, anybody? I mean, in terms of actually, or now currently, and this is a very live issue that I'm dealing with in the context of the ABA work and otherwise, anti-money laundering work, and the London lawyers working for Russian oligarchs. So that whole thing about, glass houses and stones and the like, I think does apply here in terms of looking at who is delivering legal services. With respect to the other parts of the equation, the market will end up actually disciplining to a certain degree itself. I think if people look at what happened with Arthur Andersen, the firm collapsed and ultimately they actually won at the US Supreme Court, but they had lost so much already. That's where ethics matters. That's where reputation matters. And that's where, again, systems are only as perfect as the people in them, and we are all imperfect.
One more quick question. Yes, at the back.
I wanted to ask you a question about if we don't have self-regulation. So let's say, if you look at the market, in order to get access to justice, when going back to the market wants it, lower pricing, you excellent lawyers, and you create a two-tier, three-tier kind of profession here. Whereas the higher tier, for example, I'm thinking of is the solicitor regulatory authority. it's not completely self-governing because the government is regulating the solicitors there. I wonder whether you think that is a better solution to law societies government self-governing. Those are examples. Now, there's more lawyers and fees are lower. I feel it's tiers.
So just to paraphrase the question, what the relationship between self-regulation and the independence of the bar?
So when you look at the Solicitors Regulatory Authority and a lot of the other developments in England after the Legal Services Act of 2007, it's quite clear it has not fixed all the problems. The problems existed and were debated for a decade before, and largely it came about that, and again, this is part of why I'm actually looking at 3 different free and democratic societies and 3 different approaches, but often as well, I'll look to England and to Australia and New Zealand as well, because sometimes they take different approaches. In all of these jurisdictions, there's a problem with disciplining lawyers. There's a problem with protecting the public interest. And they've all grappled in different ways with who should regulate and how is this system to be made better. I'm not going to say that one is better than the other, but we can learn from each other in terms of that dialogue. What is constant is that if the profession thinks that it is immune from public scrutiny, as was the case certainly in Australia, all it took was one too many really bad cases of lawyers doing clients wrong to force change into the system. The Securities and Exchange Commission is actually looking at this in the United States again. There was a commissioner's speech in March that was a shot across the bow. And I think in that respect, at least the Australian solution, taking discipline away and saying to the law societies or equivalent, you'll be involved in rulemaking, or at least who gets access to the profession, may be a better solution. But we're, again, trying to learn from each other. The SRA gets beaten up a lot. I don't know that a lot of that is justified, and at least they've tried something different.
Okay, and a question here for Ben. Section 1 of the charter doesn't contemplate just a free society or just a democratic society, but a free and democratic society. How do those concepts, freedom and democracy, inform one another? And feel free as well, Ben, in concluding, to comment on anything from Professor Muniz-Fraticelli's comments.
Sure. So I think part of I kind of make a series of competing claims. I don't think I necessarily did them justice in a 12-minute presentation, but the kind of key, I guess, as the key kind of analytic kind of claim I was making initially about the interaction between the free and democratic societies, precisely that they interact with each other, right? That they cannot be understood as kind of like a sum, kind of formalistic sum of their parts. Democracy shapes freedom, and freedom shapes democracy, and it creates what emerges out of that is something different from just pure democracy or some abstract notion of freedom. So the claim I was trying to make was kind of that based on a kind of a reading of how to think seriously about this. I tried to, I hinted at this as a method, but I was trying to make it still a more kind of basic philosophical argument. Free and so the Waldron's, where to take this from, Waldron's, he steals from a guy named, borrows from a guy named William Corbett. And Corbett, I didn't quote Corbett, but Corbett has a kind of a long passage in this book that Waldron takes it from. It's about basically the ultimate, the right of rights is basically the rights for men, but for people to participate in the laws of the government, to have some role in shaping them. And so this is where this Waldron's idea comes from. So if you take that seriously, and it hints at things like self-government in the secession reference, one of the things that I was trying to, I guess it was a kind of methodological disagreement, the danger of a kind of an essentially contested concept like democracy is that it's just as it can't be a sum of freedom and democracy in the free and democratic society. There's an inevitable kind of so in the longer part, which I didn't include in the quote from Dixon, he lists kind of a series of things he says seem to be kind of crucial components of a free and democratic society. And the danger I didn't mention this at all, but in the paper is that there's some kind of that's where the essential contestability comes in. right? Where like some of us may think certain values play a role in free and democratic, some of us don't. So to avoid these, this is a circumstance of politics. A more kind of maybe procedurally legitimate way of dealing with this essential contestability in the context of thinking about rights is to ensure there is a participatory component, not because the participatory component is the kind of capital T truth per se, but if we take humans as rights bearers seriously, it entails a certain kind of expectation of people that they can play a role in thinking about these basic normative questions, and that reasonable disagreements between them may be better solved by more participatory institutions. So, I'm saying that I say in the paper that we're choosing between different concepts, and I'm staking a claim for one of those concepts. What I'm trying to do is suggest kind of in Waldranian terms why the way I've framed it might be a kind of necessarily more plausible, but a more kind of realistic way of dealing with the inevitable challenges that are the essential contestability of the free and democratic society just inevitably create.
Thank you, Ben. And last word to you, Professor Payton. You've done a lot of work with studying legal ethics, working with bar associations. You recently served as interim chief executive officer of the Canadian Bar Association. The idea of a legal profession isn't just a theoretical or academic one. It's something relevant to all of us here in the room today. How do we as lawyers, through our work as lawyers, how do we contribute to a free and democratic society?
Again, one of those easy and I think part of the answer actually lies in events like this. Thinking about and sharing ideas about how we can do better and more to serve. And I think in terms of who we are as lawyers, there is that sense and sensibility, sometimes lost too much, in the sense that, well, the profession used to be focused on that and isn't anymore. We need to redouble our efforts to take part, to serve the public, to be reminded of what a privilege it is to actually be in a free and democratic society and how important the work we are doing, whether that's in family law, whether that's in policy, in government, in the academy, or otherwise. We are positioned to make a contribution. To an individual client, we are the bulwark against the awesome power of the state. For lawyers working in government, they are actually greater advocates and allies for a better and more productive future through the work that they are doing. So if we spend time focused, Derek, as you've done today, in how do we do better and how do we do more, in contributing through the Bar Association, through other organizations, to making that positive change, I remain inspired by what my students are engaged in and what they will continue to be engaged in as they move through the profession. And it was an honor and privilege to serve with the Canadian Bar Association for that brief time to help empower the profession to remain advocates and allies, and importantly, to engage in public education about what we can be doing better and more. Thank you for the question and the opportunity.
What a fantastic note to end on. Will you join me in showing appreciation for this? Well, I'm sad to say that that does bring our day to a close. The good news is you've stuck with us throughout the day, so you have earned 5 hours of CPD credits with the Law Society of British Columbia. Congratulations, and thank you to the Law Society of British Columbia for the privilege of the accreditation. But we just want to close with a word of thanks. Thanks to all of you for taking time out of your very busy schedules to be part of this conversation today. Your questions have really enriched our dialogue. I know a number of them we didn't get to, but we've collated all the emails and texts and notes that we've received. We will be sharing that feedback with all of our panelists, who I know will greatly appreciate it as they develop their papers for publication. On that note, we're very privileged to share that LexisNexis Canada has agreed to publish the collection of papers culminating out of this event in the Supreme Court Law Review. It'll be published sometime next year, so please stay tuned for that publication. Also excited to announce that our publication from last year's symposium on forgotten foundations of the Canadian Constitution will be published later this month in the Supreme Court Law Review, so stay tuned for that publication as well. Brian, we have a lot of folks who really want to thank as well, and I really want to thank you, Brian, and the whole team here at Peter A. Allard School of Law, especially Michelle Burchell, who's been an incredible support logistically in making this possible. And Rowan Sheehan, who's behind the scenes and been with us all day working on our tech. Thank you, Rowan. We've had great support from the team at Christian Legal Fellowship. We've had a number of student volunteers with us today. Thank you so much to our students. Thank you to Ruth Ross and Maria Stonhouse, Anna Marie Carruthers and Leah Malusis and the entire CLF team. Really appreciate all of your support in making this logistically possible. So thank you to the CLF team. Also very grateful for a very generous connections grant from the Social Sciences and Humanities Research Council, which provided funding that made this program possible. So great thanks to SSHRC for their support. And thanks so much to all of our speakers, very distinguished guests throughout the day who donated and supported and contributed your time to enrich this conversation, to do exactly what Professor Payton encouraged us to do, which was to think collectively about our shared contributions and commitment to cultivating a free and democratic society. And this was very, very encouraging. And a very special thank you to Justice Ian Binney, not just for your talk today, sir, but for your life of public service. Both in public office, but also as a member of the judiciary. And we want to salute and thank you for your contributions to Canadian jurisprudence. Thank you. Brian, I just want to hand it over to you for any other concluding announcements or comments.
Sure, just wanted to add a couple more thank yous to the team at Allard. We also had today on the floor, basically making sure things were going on, the coffee, the muffins, everything behind the scenes, Cameron McCaw, who also works here at the law school, and also some emergency printing services that were taken care of by our receptionist. These events, as those organize them, there's so many hands and feet involved, and we are just so lucky here at Peter A. Allard School of Law to have an incredible team. So please, one more round of applause for everyone. And my thanks to CLF for all of the work that they've done to make this wonderful event possible, and to our speakers who, as I said at the beginning of the day, I was told by many people prior to today that we had an amazing lineup, and I think what you've seen in the various talks and comments and presentations is borne out to be amply true, that we have had just a wonderful day, very rich in a lot of food for thought. And speaking of food, we're really moving towards the kind of evening portion of the symposium. So for those who have spoken today, our panelists, our discussants, our speakers, you're invited to dinner, which is on the 4th floor. And for any guests who have been invited, you'll know if you're invited because you were invited by us to dinner. We wish you could have dinner for everybody. It's just, amongst other reasons, the size of the room that we're using just doesn't accommodate the many people, the numerous people that we have here today. But we do have one more talk this evening. It's going to be by Justice Joyce DeWitt Van Oosten of the BC Court of Appeal, speaking on Section 1 of the Charter. That will happen after dinner in the same place where dinner is happening. I can't guarantee that there'll be seats for everybody, but there might be standing room only. But you're more than welcome to come for that talk, even if you're not going to be joining us for dinner. It's scheduled for 7 p.m., but I would not be surprised if the talk is more kind of around 6:45 or so. So with that, if you're able to stick around, there are still options on campus for food. You're more than welcome to come here, Justice DeWitt Van Oosten to speak, probably around 6:45 or so. So with that, I just want to move to the 4th floor for those who are joining us for dinner. But I just wanted to thank you all for being here today. This was a wonderful day, and we've been looking forward to this for so long, and it's really you all delivered. Thank you so much. Thank you, everyone.